My name's Hugh Reed. Thanks for joining us, watching or listening to an update of the 2011 Multi-State Bar Examination. Now, I just got back from taking the exam. I take it virtually every time it's given, and I study the exam. Now, some of you have just taken it. You know there's been a lot of changes on the examination. So, I want to give you those, the updates. Now, I hasten to say I'm prohibited from giving you the exact questions because that would be an infringement of copyright. Indeed, everybody who takes the exam has to certify that he or she takes the exam in order to be licensed in that jurisdiction. And I want to be licensed in as many jurisdictions as I can because I'm the managing partner of a law firm, Reed Law Group Ltd., that provides legal services for servicemen and women around the world. So I want to be licensed in many states. Unlike other law professors, however, who portend to give you advice on the multi-state, you know, I take it on a regular basis, and I've taken and passed over 20 multi-state bar exams. The largest traditional bar review, for which I used to work, has many law professors, including its CEO, who teaches multi-state subjects around the country, has never taken and passed a multi-state bar exam. So, probably doesn't know a lot about it. In fact, I know he doesn't know a lot about it, because I listen to various lectures on airplanes as I fly around the country, and I'm amazed how little they know about the exam. Some don't even know how it's tested on the exam. So what I want to do today is, first of all, provide you some information on the multi-state bar exam. What is it? Secondly, why it's so important. In fact, it's determinative on whether or not you'll pass your bar examination. Third, the types of questions that are being currently tested on current multi-state bar exams. Fourth, the recent changes on the bar exam, and I'll cover them for you. Five, how do you prepare for the multi-state bar exam? How do you prepare for it? And number six, why I believe we provide the most relevant services for multi-state training. In fact, our students nationwide will have scored the highest scores on the multi-state bar exam, on the average 20 to 30 points higher than those who study with other materials. So what is the multi-state bar examination? Well, first of all, it's a uniform, confidential, 200 multiple choice question examination. Uniform, meaning it's the same in all 48 states and several U.S. territories. Louisiana and Washington State do not use the multi-state, but all other states do. So, it covers 6 subjects: constitutional law, contracts including the law of sales, criminal law including criminal procedure, evidence, property including future interests, unfortunately, and torts. So 6 subjects, 33 questions in each subject, except contracts and torts, where you'll be tested in 34 questions, respectively. And since about a couple of years ago, 10 questions of 200 questions are now experimental questions. That is, you are the guinea pigs for future takers. So, the number you get correct out of 190 is your raw score, and added to that raw score are a number of points to achieve a scaled score based on the difficulty of that exam. If the group does very well, they'll add less points. If the group doesn't do as well, they'll add less points, so that your score is approximately the same score as candidates who came before you. And that score will be sent to your law examiners or bar examiners, wherever you're taking the examination. So 10 questions are experimental. Up to 60 questions, however, are repeat questions from past exams for statistical equating purposes. That's why it's so important for you to study with materials that are relevant, all right, that someone has actually seen recently and can give you those points that you need. Approximately 70,000 candidates will take this exam per year, and each jurisdiction will take this examination. They'll use it somewhat differently percentage-wise. Most use an equipercentile method, meaning that half of your score will be the multiple choice part, the other half will be your written and essay part. Some jurisdictions, California, 35% multi-state score. Other jurisdictions, Texas, Arizona, 40% of your total score will be the multi-state score. So each jurisdiction will use that multi-state score somewhat differently. But here's how they all use it the same way. And this is very important. All will use it as an early item analysis or early indicator whether or not you'll pass your bar examination. Indeed, the director of testing for the National Conference of Bar Examiners recently said that most jurisdictions only grade essays of those with moderate MBE scores and do not grade essays with very high MBE scores because those candidates are assured of passing, whereas those with low MBE scores are most assured of failing. Indeed, in 30 years of preparing people for the bar examination, I've never seen anybody with a low MBE score pass the bar examination because their essays brought their scores up. I've only seen people with high MBE scores, and those points will carry over to the essays for candidates to pass their bar exam. So, that is the MBE in a nutshell. 200 questions, multiple choice questions, confidential, secured, all right? 6 subjects, 33 questions in each subject other than torts and contracts, 34 each. 10 questions are experimental. And then your scaled score will be sent off to the examiners. Now, why is it so important? Well, it's so important because it's the most important game that you'll ever play, believe me. It is so important you have to fight for every point. In most states, in fact all states that I know of, other than Louisiana and Washington who don't use it, it's the key to you passing your bar exam. The higher your MBE score, the more likely you'll pass your exam. States use that early MBE score, they'll get in a matter of days, to segregate potential passers and potential failures. And in some states, you're automatically admitted if you get a high enough MBE score. Other states, you can carry it over for your next bar examination if you achieved high MBE scores. So the higher you score in the MBE, the extra points carry over to your essays. Now, what type of questions are being tested currently? Well, the exam changed a little some time ago, but the 5 types of questions are best of the lot, best of 4 bad alternatives. Second, worst of the lot, the worst of 4 alternatives. Third, dichotomy questions, 2 answer choices holding one way, 2 answer choices holding another. Fourth, we used to see case squibs in criminal law. They gave you cases, and you had to analyze those cases and how they compared to other fact patterns. And fifth, tier type questions, or Roman numeral type questions, where they gave you several Roman numeral propositions, and then you had to pick the best combination. On recent exams, we haven't seen any squib questions, we haven't seen any Roman numeral type questions, but we've seen a lot of 3-to-1 splits. A lot of 3-to-1 substantive splits, 3 answer choices holding one way and 1 holding the other. Now if you think about it, a monkey with a banana would get 50 questions right out of 200. I know only 190 count towards your raw score. But 4 answer choices, so it's really 800 true and false questions. Give a monkey another banana and he would get 50 right. They're only asking us to do about twice as much as well as a monkey, and the average mean score, mean, meaning they've added a number of points to achieve that score, on recent exams has been right around 140. 140. That doesn't mean raw. Raw, probably 125 or thereabouts. Correct. 125. Correct. All right? All right. So, what are some of the recent changes on the multi-state bar exam? Now listen up, this is important, because if you study with materials that is not reflective of what's being tested, and I promise you that our materials reflect the most recent nuances and fine line hornbook distinctions that are tested on the multi-state bar exam. It's not enough just to know the right answer. You actually have to jump through a second or third hoop in order to analyze the set of answers so that you end up choosing the right answer. Or what we like to say is back into the right answer, because you're deductively eliminating answer choices which cannot be the correct answer. What are some recent changes? Many new changes in criminal procedure. Many changes in criminal procedure. Misprision of felony, allocution in sentencing hearings. That's new terminology. Also grand jury hearings, double jeopardy, search and seizure questions I've already mentioned. So new terminology. Misprision of felony. Well, concealment of a felony committed by another person. Under the common law, it was a felony to hide a treasonous kind of crime. It was a misdemeanor for all other crimes. Misprision of felony has been abolished in most jurisdictions, not the right answer. Allocution in sentencing hearings, the defendant can explain himself, allocute himself, has an absolute right to allocute himself before sentencing is passed. Well, you had to know that, but you also had to know that the right against self-incrimination regarding factual matters at sentencing applies, and a court may not draw adverse inferences about that factual issue from defendant's silence. Mitchell versus U.S. 1999 case. No Latin or foreign terms have been the right answer on recent exams. French terms, profit apprendre, force majeure, throw it away. Sucker choices, right? Red herrings. Even our old friend, res ipsa loquitur, Latin terms, not the right answer, have not been the right answer on recent exams. More and more substantive 3-to-1 splits, I've already talked about. Fact patterns continue to be very long, especially in contracts and property. The evidence questions, good news, short fact patterns, and the plaintiff's names still start with a P, defendant's names with a D, and witnesses' names with a W. In property, the examiners continue to introduce statutes, particularly in recording acts and notice issues. And other concepts that are not covered by general bar reviews include continuing trespass doctrine, or after acquired intent doctrine, riparian water rights, partition proceedings, federal statutory crimes, assignability of mortgages, concomitant wills, how they relate to property transfers, and the Fair Housing Act of 1968. So, you got to know those. How do you prepare for the MBE? Use only realistic questions. Ask whether or not your law professors or the lecturers have taken the MBE recently. Keep track of where you're missing questions according to the outline published by the National Conference of Bar Examiners. And start your studies early. We recommend up to 5 months before the bar examination, because it's true, the early bird does get the worm. Now, why do you need us? Well, we're relevant. We take the exam. We're the nation's leading experts on the multi-state. Our students generally score 20 to 30 points higher in the multi-state than other students who take other bar exams. Again, 60 out of 200 questions are repeat questions from past exams. And I want to make sure that you understand what is being tested. We have a complete part of the company that dedicates itself exclusively to studying the multi-state bar exam. And we teach the essential strategies and tactics for you to do well. We simulate MBE testing conditions, and overall, in some states, we've had a 100% pass rate of our students who opt for to be tutored by us personally. And I think if you need to pass, call us about that. And you can supplement your other studies, if you're taking another bar review already, with our multi-state materials. Look for our final multi-state bar review, which will be offered approximately a week before the actual exam. Follow us on Twitter. Take a free diagnostic exam on our website. And call us for more information. We know if you use our materials, you'll pass with plenty of points to spare. Thanks for watching or listening.